Hello, once again, welcome to the Law Professor. In this presentation, we shall be looking at dissolution of marriage in the context of desertion under the Matrimonial Causes Act. So that means we are speaking to statutory marriages in Nigeria, statutory marriages. As we proceed with this presentation, I would enjoin you to subscribe to this channel, to share, and to like. Dissolution of marriage, we have looked at some of the facts that the court would consider as constituting elements or the fact of irretrievable breakdown of a statutory marriage. And we have looked at some of the provisions of the MCA. In today's presentation, we shall be focusing on what we call desertion. How can desertion constitute an element, can constitute a fact of the irretrievable breakdown of a statutory marriage? Irretrievable breakdown of a statutory marriage. In this presentation, therefore, we shall be looking at the following learning outcomes. One, to be able to determine what is meant by desertion under the Matrimonial Causes Act. And if we are able to decide that, we shall look at some of the elements of what is meant by desertion. The elements. How do you prove? What are the components of desertion? What are the components? The presentation shall also address what we call constructive desertion. And at the end of it, we shall be able to apply the principles of desertion and also be able to understand and apply the principles for determining when desertion ends, termination of desertion. Now, essentially, since I've mentioned the Matrimonial Causes Act, you would therefore know that we are talking about statutory marriages in Nigeria. In continuation of discussing the provisions of Section 15, we are looking at Section 15(2)(d) of the MCA, which provides that the court hearing a petition for dissolution of marriage shall hold the marriage act to have broken down irretrievably on the fact that the respondent has deserted the petitioner for a continuous period of at least 1 year immediately preceding the presentation of the petition. So you would note those words that have been highlighted in the slide. There is desertion, and we shall be explaining what we mean by desertion subsequently. Then it must be for a continuous period of at least 1 year, continuous period, immediately preceding the presentation of the petition. So it must be continuous. There must be a period of 1 year that you can account for that someone has decided the marriage. That 1 year must be immediately preceding the petition, so that if, for instance, the petition is brought today, the 7th of May, or the 7th of January 2024, then you have to look back to the last 12 months to count the 1 year as immediately preceding it. So if the petition is brought on the 7th of January 2024, and the respondent has deserted for a period of 9 months or even 12 months, ending in November 2023, you cannot form your petition on the basis of that desertion, because it is not the period of 1 year is not immediately preceding the time of the presentation of the petition. So 1 year must be accounted for. It must be continuous. It must be continuous, unbroken, even though we are going to look at some aspects of this where the law makes room for people to reconcile, so to say. So Section 15(2)(d) is a key section when it comes to the issue of desertion. One of the things that we must note about desertion is that it's one of the grounds that survives the matrimonial offense regime. Even though we are running a no-fault regime now, technically, but not actually essentially. But desertion was one of the matrimonial offenses that were recognized at common law as constituting a basis for ending a marriage. So those elements that can be found under Section 15(2)(d) should be noted carefully. that there is desertion, that it is continuous for a period of at least 1 year. So if the person has been in desertion for 1.5 years, immediately preceding the petition, for instance, you can still bring the petition. But the court is looking out for at least 1 year. The meaning of desertion. Desertion is the separation of one spouse from the other spouse with an intention to end cohabitation permanently, without reasonable cause and without the consent of the other spouse. One spouse brings cohabitation to an end with that intention to end it permanently, not temporarily, not, oh, I want to go on vacation briefly, not I am going for employment briefly. It is done with an intention to bring cohabitation to an end permanently, without a reasonable cause and without the consent of the other spouse. So we'll be looking at the elements of desertion that we can derive from that definition. There is what we call de facto separation of the spouses, physical separation. Usually you can find that physical separation when one person just moves out of the house. Maybe there has been conflict, there has been quarrel, there has been, domestic abuse or whatever it is, and one person moves out. So it is usually easy to find physical separation. So physical separation, this means one person physically moving out of the matrimonial home, usually in most cases. But there can also be emotional separation, which has been recognized as constructive, where they are living together physically in the same building, but they are emotionally separated. The husband and the wife are emotionally separated. So they are not maintaining what the law calls the same household. They are not maintaining the same household, even though they are living physically in the same building. There has been an abdication of consortium, of the elements that makes up for a marriage. Now, in the English case of worker and worker, you had a situation where the couple, they were in the same building, but they didn't talk to each other. There was no communication except by notes. If there was any need to communicate, they wrote a note and put it on the table, and the other would see it. There was no interaction with themselves, but they were living in the same building. That's an example of emotional separation. And you can compare that with Lebrock against Lebrock. So the law is looking out for a situation where there is actually no interaction, no emotional interaction. If there's any element of the couple maintaining the same household, even though it is conflicted, there is likely to see that they are still living together. Ricketts, another illustration of emotional separation, where the courts held that emotional separation, when they were not interacting, even though they were living together in the same building, the court said that that was an element, that's an example of constructive desertion. So what the English courts have interpreted it to mean is that desertion actually encompasses not just separation from a place, but also separation from a state of affairs, the state of affairs called marriage, what we regard as ordinary characteristics and responsibilities of marriage, where one party withdraws from that, even though the person is physically present, it will be regarded as emotional separation or constructive desertion. Now, that physical separation is needed or emotional separation. Under Section 15.3 of the MCA, the section provides that for purposes of subsection 15.2 E and D that we are talking about, the parties to a marriage shall be treated as living apart, unless they are living with each other in the same household, unless they are living together in the same household, Section 15.3 of the MCA. And the MCA does not define the concept of household. It doesn't define it. But from the cases that we have talked about and other cases, the idea of desertion being separation from a state of affairs and not necessarily from a place is pungent. And therefore, the same household incorporates the idea that you maintain the elements, the components of marriage, the issue of consortium, having the same, what you'd ordinarily expect that will flow from marriage, eating together, sleeping together, doing each other's runs, communicating with each other, and all those things that make up for a household. In the case of Mansa and Mansa, for instance, the couple were in the same house. They had separate rooms. They shared their meals, but there was no sexual intercourse. And the court held that they were still living together because they were sharing a meals and their meals, and they were, watching TV together. There was still that element of communal living as husband and wife. In Fula and Fula, where the wife moved in with another man, physical separation had taken place. Even when she accepted the husband back as a lodger, because the husband was ill and she had to take care of him, the court held that they were not living as husband and wife. They were not living together. There has been desertion, there has been separation. The ingredients that we are talking about also help in interpreting other provisions relating to living separation, living apart provisions of the MCA. So the idea of desertion usually under the common law is that there is not, it can be separation from a place or separation from a state of affairs, which clearly exhibits the fact that the person has withdrawn cohabitation and intends to put the marriage to an end. Now, the elements of desertion will continue with the issue of animus deserenda, intention to desert. It is not sufficient that the person physically separates or emotionally separates. There must be that intention to desert, to withdraw from cohabitation permanently, to bring the marriage to an end. So the fact that one person has separated does not mean automatically that there is desertion. The court is looking at that intention to desert. And in Santos and Santos, the English Court of Appeal held that mere physical separation is not enough. There must be an intention to end cohabitation permanently. In the Nigerian case of Good Luck and Good Luck, where the husband lied that he was going on vacation, but went ahead to Malaysia to marry another wife and set up another family, he was held to be in desertion. So it's not sufficient to be physically separated. There must be that intention to bring cohabitation permanently to an end. And it must be done without just cause. There must be no reason. If, for instance, because of domestic violence, the husband beats off the wife and the wife moves out of the house, there is physical separation by the wife. But that is an example of what the law will call constructive desertion. The wife will not be in desertion. I will be talking about that soon. But the husband may be held to be in desertion. So there must be no just cause. If there's a good reason, a just reason why the spouse has physically separated or emotionally separated, the court would hold that there is no desertion. In Anioke and Enioke, the fact that the spouse had to go and take up a transfer appointment, was transferred by the employers to another location, was held to be a good cause, a just cause for moving away, even when the spouse did not agree. So that person is not in desertion if because you are transferred. Even when the spouse refuses to consent and does not feel happy about it, the fact is that the spouse that is moving away is not moving away with an intention on his part or her part to bring cohabitation permanently to an end. You can also see the case of Omotunde and Omotunde. There will be lack of consent. The law requires that the other spouse that you have left behind has not consented to the physical separation. Consent may be expressly given, it may be implied by conduct, but consent must be absent for there to be desertion. If consent is given, then of course that would also mean and be an indication of the fact that there is no intention to permanently bring cohabitation to an end. So that means that you can actually live apart, away from each other, and still be regarded as being married. So in the past, the couple are living apart or are living separately in different buildings or whatever, does not necessarily mean that one of them is in desertion or they are living apart. We'll be looking at the law regarding living apart in the next presentation. Now, there's what we call constructive desertion. Constructive desertion. Section 18 of the MCA says that a married person whose conduct constitutes just cause or excuse for the other party to the marriage to live separately or apart and causes that other party to live separately or apart shall be deemed to have willfully deserted the other party without just cause or excuse. Notwithstanding that that party may not, in fact, have intended the conduct to occasion that other party to live separately or apart. So what the law is saying in section 18 is the fact that Sometimes it is not the person that moves out of the home that is in desertion. It might be the person that has stayed back. If a wife, for instance, discovers that the husband was having an affair and gets angry and moves out of the house. If the worst of domestic violence, one moves out of the house. The person that is moving out may not necessarily be the one that is in desertion. It's actually the person whose conduct has necessitated the other person moving out of the house that is regarded as being in desertion. And that's what is called constructive desertion. And you can see the case of Nana and Nana. That's section 18 of the Matrimonial Causes Act. Section 18 of the Matrimonial Causes Act of Nigeria. So this constructive desertion, of course, has been expanded in English law, common law, to include not only where one person's conduct has forced the other spouse to move out of the house, also situations where they are even living together in the same household, but there's emotional desertion, emotional separation in the earlier cases that we have talked about. You see the case of Ricketts and Ricketts, where that was done in English law, the fact that they were living in different bedrooms, and the wife had sworn that she would actually not have any matrimonial relationship with the husband, was regarded as an emotional separation that is constructive desertion by the spouse. The time, remember that we said that it must be a period of at least 1 year immediately preceding the presentation of the petition. That is a unique factor for desertion as compared with the living apart provisions of the MCA, which talk about 2 years or 3 years, respectively. In this regard, Section 15(2)(d), Section 17(2) of the MCA says that in considering for the purposes of Section 15(2) of the MCA, whether the period for which the respondent has deserted the petitioner or the period for which the parties to a marriage have lived apart has been continuous, no account shall be taken of any one period not exceeding 6 months, or of any 2 or more periods not exceeding 6 months in all, during which the parties resumed living with each other. But no period during which the parties live with each other shall count as part of the period of desertion, or of the period for which the parties to the marriage lived apart, as the case may be. This is meant to assist the parties in coming to making some efforts to reconcile, even when there has been desertion. So we should take note of Section 15(2)(d) and read in conjunction with Section 17(2) of the Matrimonial Causes Act. The desertion is aborted once any of the elements is broken. Once, for instance, the person that has moved out resumes cohabitation before the end of 1 year, for instance, then that is the end of the desertion. Or where the person offers to return. In other words, the intention to permanently end cohabitation is aborted, and if the person now offers to come back into the matrimonial home, then that means desertion has ended. If there is no just cause for refusing that offer by the person who has remained in the matrimonial home, that person who has remained in the matrimonial home may now begin to be held liable for desertion if the person refuses to accept the order. Of course, the facts of each case will determine whether that person can be said to be in desertion. If there are good reasons why that person is refusing, in the light of the facts of the case, the person may not necessarily be held to be in desertion. Also, if before the person left, the person in desertion, there was no consent. Remember that we said one of the elements is that the other party did not consent to the separation. So if therefore, subsequently, that other party who did not consent now consents to the separation post the desertion, then desertion ends and the party that has left will not be held to be in desertion. In summary, therefore, under the Matrimonial Causes Act, which we have established in earlier presentations, apply exclusively to statutory marriages in Nigeria, one of the facts that can demonstrate that a marriage has broken down irretrievably is that the respondent has deserted the other spouse. This desertion must be for a continuous period of at least 1 year immediately preceding the presentation of the petition. The desertion may be ordinary desertion, where the person physically moves out of the house without just cause, without the consent of the other party, and with an intention to bring cohabitation permanently to an end, to end the marriage. So it can be a simple case of desertion, or it can be constructive desertion, where the court will hold that the person that moves out is not necessarily the person that is in desertion, but the person that has stayed behind, but whose conduct has forced the other party to leave the house. Or where like in English law, where there's emotional separation, of the parties. The elements of desertion have been highlighted, therefore, to include de facto separation, animus de surrender, intention to bring cohabitation to an end permanently, lack of just cause for the living, and lack of consent of the other spouse. This desertion can be broken where any of these elements have been jeopardized, have been brought to an end. In the next presentation, we shall be looking at the living apart provisions. Please remember to like this video, share it, and subscribe so that the reach can be wider and we can be encouraged to give you more presentations.